Hello, everyone, and welcome to this special session being hosted by Mansory Law. I am your host, Tammy Pettigrew, aka the Cannabis Cutie, and we are here today to talk about the new LA ordinance that affects all operators. There's a lot of information to get through. I'd like to first start by introducing our lawyers for today's talk. We have Maytal and Alexis, and I'll let them introduce themselves.
Hi, everyone. Thanks so much for joining. A lot of familiar people in the audience. We appreciate your support and attendance, and hopefully we can answer your questions today. We are headquartered in West Hollywood, though Alexis is in San Francisco, and we have lawyers and legal specialists pretty much throughout the state. I'm the managing partner for Mansory Law, which I founded in 2010. Since 2010, I've been trailblazing the cannabis industry alongside a strong team of attorneys and legal professionals behind me. I began the firm on the principle of the importance of female equity in the legal industry and in business generally. And I'm proud that we've, as a firm, fostered and nurtured many of today's leading lady lawyers in the space. As far as my legal specialties, I work mainly in regulatory compliance and also structure for corporate transactions tailored to the complicated regulatory framework that surround hemp and cannabis. I'm also very excited and eagerly watching the psychedelic legal landscape. And I'm going to be barred in Colorado soon as that's become legal there. And we're really excited to see how that gets brought into California and LA. So more on that, stay tuned. I also serve on the executive committee for the International Cannabis Bar Association and the LA Bar Association Cannabis section. Anybody in the audience who's a lawyer or a law student should really look at both of those organizations. They're great for ongoing education, networking, support. So I really want to promote those. For International Cannabis Bar Association, you can apply to be a member. You can use Mansory for a discount code. I think it's like 15 or 20%. So hopefully you'll join that. They're putting on an intellectual property symposium in September. There'll be an MJ Biz, lots of exciting stuff happening with that organization. With regard to today's topic, I've been on the front lines of LA cannabis regulations for almost 15 years. And I really enjoy being a part of legalization and the regulatory movement and providing education and materials for operators and for young lawyers. So I'm really excited for today's webinar.
Hi, I'm Alexis. A little about me. I graduated from UC Berkeley and I went to law school at UC Law SF, formerly UC Hastings. I actually started in the cannabis industry as a trimmer following my graduation from Berkeley, pre-2016, so like 2012. And then on the legal side, I got involved with INCBA, the International Cannabis Bar Association, actually as a law student in 2017. Was sort of my first foray into this industry. And I found out that I could do this as a legal career. And I parlayed, my connections in that association into jobs. So yeah, I would also plug INCBA. I think it's a great organization. As far as me, I'm pretty passionate about changing the stigma about cannabis consumers and what that means to be a pot smoker. I'm obsessive about regulatory compliance and staying abreast with what's going on in cannabis. I read constantly, so always know what's going on.
Thank you, Alexis and Maytal. Great introductions. And again, I'm your host, Tammy Pettigrew. I am an educator in the space. I advocate on many of the news and science that comes out. And I love to host and have these kinds of discussions. So thank you for allowing me to be here to moderate today's panel.
Tammy.
Yeah, all right. So we have so many topics to talk about. As with all new legislation, there's a lot of words, and we're here to help make you understand them clarify it a little bit and answer any questions that you have. If you do have questions while we're speaking, go ahead and put them in the chat and we'll try to get to them as we go through each section. All right, so first, should we go over the slide with all the points or should we just get into it, Maytal?
I will just sort of give a little intro into what the biggest changes are, I would say, like the key takeaways for LA. So as we know, the LA ordinance is always evolving and changing, and all of us in this space as professionals and operators have to, like Alexis said, stay on the forefront, know what's going on, because if you're a day behind, you're late, so this is kind of the big broad strokes of what's changed in LA. And the interweaving with like a state application, so everybody I'm sure on this call knows that, but just in case you don't, you need a local LA license and a state license. So there are two different kind of pathways that you have to go down anytime you're trying to get a license to operate any kind of commercial cannabis. In LA, what's changed has largely affected current operators and expanding their ability to relocate, and then also affecting their ability to operate from an annual license perspective. So basically, since legalization, we have been in kind of like this temporary provisional licensing phase, and that has sunsetted to a large extent, almost completely, except if SB 51 passes, which we'll talk about later. But so everybody's been on a temporary or provisional path. Now you have to be on an annual path for both the city of LA and the state of California, which is pretty new within the last few months. That's really kind of where the rubber has begun to meet the road. And so LA has had to come up with, had to actually create more details for their annual licensing program in order to be in compliance with the state's annual track. So, the state kind of sunsetted its provisional, so then the city also has to sunset the provisional process. And that's largely for many reasons, but one big reason is CEQA, which is the Environmental Quality Assurance Act in California, which has a lot of teeth when it comes to a new market or a new industry and regulating the environmental compliance issues. So that kind of all comes together in this moment where we're seeing this changeover into the annual process and what that's going to look like at the city and at the state. A new fun thing that we get to talk about are these people that were deemed ineligible due to sensitive uses during phase 3 round 1. There's only about 12 people, I believe, out there that this applies to, but it's a new change that we want to talk about. Also, the aggregation of social equity interests. That's this unique new opportunity for social equity applicants to form like a group or an entity. So we'll talk about that. And the updates on the next round of the social equity lottery, we can answer some questions about that, but as far as the date, it's kind of TBD. So those are the broad strokes of what's going on.
All right, so you mentioned that some people would have the opportunity to relocate, and I'll just remind everyone that's just for the city of Los Angeles.
Right.
How can they relocate and where can they relocate to?
It's of course not simple, and it's lawyer's favorite answer, which is it depends. So depending on your license type and where you're located and where you want to move to, the answers are going to be all different. Previously, there were only some, so there's the undue concentration concept based on community plan areas, which means that only a certain number of license types can be in each community plan area. And each community plan area encompasses maybe a couple of districts, right? It's just kind of this like zoning issue that is its own thing through the planning department. So each community plan area has a limit of each type of license when it comes to cultivation, and manufacturing and retail. So not delivery, ignore the delivery note, but those licenses previously could not relocate, and theoretically, under the new ordinance, they now can relocate to a new community plan area, which was previously prohibited. But as you'll see, there's some tricky issues when it comes to that. Okay, so moving on, so they'll be able to move to any new community plan area that has not reached undue concentration. So this is where it gets a little bit tricky. Basically, let's say in any community plan area, 100 retail license, or 100, let's say in any community plan area, 10 retail licenses are allowed. So if that number is 8, there are 2 spots open for you to relocate from any community plan area into that area. The retailer map is pretty up to date on the DCR's website. So as far as retailers go, this isn't super difficult to allocate where you want to move to, and it's on the DCR's website. You can go to the map and check it out. And I think some of the open ones are Hollywood, maybe Wilshire, and some areas like that. So this creates flexibility for applicants and licensees. So we, especially for cultivation right now, we don't know exactly where cultivators can relocate to. So in 2018, when phase 2 started, that was where anybody could apply for a cultivation license that met certain requirements besides the pre-ICOs. And that's when the cultivation licenses were originally given out. Rumor has it that there were so many cultivation licenses applied for and temporary approval granted that the city far exceeded acreage in cultivation beyond the undue concentration limits. And so where we stand now is we know that a lot of those original licenses have lapsed, have been abandoned, have relocated, but we're still waiting to see basically where the dust settles on the various community plan areas when it comes to cultivation. There are several tricky things about the cultivation undue concentration metrics that I think is making this pretty difficult for DCR. But they're saying that they're going to have some information for us by next week. And I just want to plug the LA Bar Association for that, because they really have been active in trying to get that DCR to develop that information. I think this is, you know, partially they're getting this together because of that. Okay, so just another thing to note, if you're moving in the city, that's great, you can relocate. Unfortunately, if you have a state license, you will not be able to relocate that state license. So you will have to get a whole new state license at your new location. And because we've passed that provisional deadline, you have to apply for a state annual license, which, as Alexis will tell us, the timelines are tricky and long and not great. So that's just something to keep in mind. If you are looking to relocate, you will need a physical location to relocate to, and you'll have to have that location reserved in some way, whether it's with a lease or some sort of contingency agreement with the landlord. Upon licensure, you'll need that property for probably a year before you can operate.
Okay, there does seem to be a question in the chat that might pertain to what we're talking about. The question was, is there a number or name for the license transfer?
Is there a number or name for the license transfer? Are you asking about how you would do it in the portal? I'm not sure about that question.
Okay, we will wait for them to get back to us on a follow-up for clarity. All right, so the annual licensing application, there are new requirements. Can you talk a little bit about what those are?
Yeah, so on May 1st, the DCR basically launched their annual licensing process. If you have temporary approval and you've already created a legal business entity record, probably received an email prompting you to follow a couple more steps. Once your annual record has been created, they are asking applicants to submit 3 items: an updated premises diagram, your current lease agreement or property deed, and then the CEQA project information form, the LIC 4013 form. We'll talk a little bit about that in a few slides. With the launch of the annual licensing process, also comes the sunsetting of the temporary approval. So as of June 30th, the DCR is no longer accepting non-social equity applicant temporary approval applications. And in a couple of days, as of July 31st, the DCR will no longer accept temporary approval applications from social equity applicants. So the temporary approval program, you'll still be able to renew your those each year up until February 28th. I see that is actually says February 18th. It's supposed to be the 28th. That was my bad. But on the 28th of the 2027, basically, and all temporary approval licenses will basically cease to exist as of the December 31st of that year. So with that, you'll have to be either working towards your annual license or yeah. So in addition to the annual license application, there is now an ability to refile if you have a temporary approval application that was either abandoned or expired after June 30th. You now have to file as an annual license and no longer as a temporary approval application. Let's see. Okay, next slide. Yeah. And with the changed ordinance, they now allow applicants a 3-year period for reapplication. It previously was 1 year, so additional 2 years is significant. Oftentimes people lose site control, they have various landlord issues, so that maybe application expires, but with the change might be able to move, and having the additional 2 years is kind of clutch. If you're refiling within the same community plan area, again, you will not be subject to the undue concentration requirements, but like Maytal was talking about, if you're outside of the original community plan area, you're going to be subject to only a place that has not reached undue concentration. So for the annual license application, it's just gonna take a little bit longer than temporary approval, as from the name you can sort of assume. But the core components of the license application are similar, a lot of the same aspects. So if you've submitted a DCR application, temporary approval, you've submitted site plans, a premises diagram, owner attestations, a list of primary personnel, landowner attestations, indemnification documents, labor peace agreements. Those are all going to be very similar as though they're required under the DCR rules and regulations. What is new is this CEQA, which we've alluded to, the California Environmental Quality Act. So this is the new form, that's LIC 4013. You basically have to complete that. We would encourage you to engage with an environmental consulting firm. Given that this is sort of like the last regulatory hurdle, it is quite important. And there's a lot of detailed information. You just want to do it right, So once you do that, you complete it, you upload it to the DCR portal. This sort of, the DCR reviews it, and who knows how long this takes. And this review document requires a public comment period. So you want to make sure that you're budgeting adequate time in order to complete this and get this all done, as deadlines come faster than you can imagine. And from what we've understood, the DCR has indicated that a lot of licensees who have there's an annual application created in their portal. They've not submitted this document. So if you haven't, should get on it. You also need to, like I said, demonstrate site control. So upload a premises diagram and a lease agreement.
And just to jump in, as of July 1st with the state, this July, so a couple weeks ago, the beginning of this month, you would need to be responsible for additional CEQA requirements. So if and when you renew your license from this point forward, there may be, there are CEQA requirements. They're not quite asking for them yet, is my understanding, but you can expect that. So you want to make sure you're prepared, just to echo what Alexis is saying.
Yeah.
All right, and under these new rules, the novel operating permit is now required. Can we speak a little bit to this?
Yeah, so more permits, more requirements, yay. Well, this currently is not required for you if you have temporary approval, but if you're going through and when you go through the annual license application process, you're going to have to obtain this operating permit. So if you have temp approval, you're sort of safe until 2027. I wouldn't look at it like that, but at some point you will have to go through this process. This will include getting a certificate of occupancy, and through that process, there are several permits and clearances, right, as described here, the fire department, the water and power, all public health, several other corresponding state agencies. Depending on if you're a cultivation, there's a couple other requirements. So yeah, once you begin to operate under an annual, you're going to have to do these. And with that, you will have to undergo a final inspection of the business premises. And yeah, if you have an outstanding notice of violation or a notice to comply based on some sort of necessary corrective action that the applicant has to do, which you typically have about 90 days to fix. If you're in that time, you will not be able to pass the inspection despite, if you have all the requirements. The emblem placard. So this is for applicants who are storefront retailers or micro businesses with on-site sales. You're going to also have to obtain another permit. This one is through the Department of Public Health. And this is part of that site inspection process, but there's an application that corresponds with this along with an additional fee. From our understanding, this needs to be complete before the DCR 2024 renewal process. If it's not by then, you will not be able to renew your license. With that, the site inspection and evaluation, the health department inspectors will basically come in and assess the building premises for compliance. They will inspect all of these such rooms, basically come in and make sure everything is compliant with. There are critical items that in order to pass the site evaluation, you have to have all of these critical items present and functioning on the premises at the time of the inspection. If you don't pass the initial inspection, there's additional fees. You have to submit a corrective plan of action, and then you have to undergo an additional inspection, so it delays the permit. So you just want to get it right on the first time. It's actually not, it looks like a lot, but it's, sinks, hot water, cold water, toilets, according to building code. If you don't, in addition to the critical items, you also have to have non-critical and general items. Though in order to pass the site inspection, you do not have to have all non-critical and general items. But in order to receive the actual permit, you will have to eventually have all of those items. Non-critical items, for example, are inoperative lights. If you have a blinking light that needs to be fixed, missing paper towel dispensers, for example, inadequate shelving. They have a requirement that shelves need to be at least 6 inches off the floor, yeah, those sort of things. And when you are ready and your premises is ready for an inspection, you complete a very simple application, submit it, pay $334 per activity, and work with the Cannabis Compliance and Enforcement Program to come out and conduct that site inspection.
All right, well, that sounds like a lot. More paperwork. But some good news, retail applicants deemed ineligible to sensitive uses can now apply under a new location. Let's talk about that.
Yeah, this was kind of an interesting add-on. There were a few folks that during phase 3, round 1, made it into the top 100, but there may have been a school nearby or something like that, so they were deemed ineligible. And now the DCR has reversed that decision, essentially saying, okay, you can find a new location. And so that's good news for those folks. I feel like as somebody that was really involved in this process, some people really, got the short end of the stick for many reasons. And so, this I think is just kind of one of the ways that DCR is trying to help those folks that maybe were just unlucky, kind of. So yeah, I think that's really good news for those folks. So they can go into their portal and basically just reapply, which is great.
All right, we do have some questions about the new ordinance that allows applicants back into the program due to sensitive use. Joseph was asking, why does that not apply to a PCN applicant that was deemed ineligible due to sensitive use?
Well, I think the premise is, well, first, as you'll see later on in our slides, the PCN process is going to open back up. So that's good news. So if you do have a location that basically the PCN versus the non-PCN process, one was kind of like a race. It was a race to get in the top 100. And then the PCN, it wasn't a race, but it was heavily tied to your location. That's the whole point of the PCN, which is you're essentially asking for a variance on the undue concentration based on your location. And for X and Y, Z reasons, your location should be exempt from undue concentration. Because that process is so, like, the PCN necessarily goes with your location. That's the whole point of it. The first 100 that applied with a location that had sensitive use issues, I mean, I could see how you guys are in a similar boat, but the DCR, I think, just went with those folks because the PCN, you had to go through, I think, city council, and there was all these processes for that specific location, why that location required a variance. So inherently, if that location is not eligible because of a sensitive use, it kind of cancels out your whole PCN application, which is based on like this variance. But the good news is for you that starting in the next couple of weeks, DCR is saying they're going to open up the PCN process. So if you have a location, then you can get your application in and go from there. So hopefully that answers your question.
Yes, Joseph, hopefully you got the answers that you needed. If not, come back to the chat. And then I just wanted to go back to the other question that we attempted to answer earlier. If you want to buy a license in Los Angeles and move it to another location, it has to be within the city of Los Angeles. That's what this ordinance is covering. All right, so next, let's get into social equity interests.
Yeah, so this is a new, and something they've been talking about for a while, but it's now finally part of the ordinance, which is the ability to aggregate social equity interests. And I think there was an appetite in the industry for there to be more opportunity for social equity applicants to participate in the cannabis industry without directly being in control of a company or directly having exactly 51%. So this is interesting because you can have a company, essentially, let's call it social equity company, and social equity company owns 51% of said license. But the company, the social equity company, is like a group of social equity individual applicants that can own any percentage of that 51%, so long as the complete 51% is owned by social equity individual applicants. So it's interesting. I'm really intrigued to see how the market treats that, if there is really this interest in that. But from my perspective, operating in the space, the requirement or the restriction that a social equity applicant be one person that owns 51%. A lot of times that one person wants a less active role, or, if you have, let's say, a social equity applicant who is very experienced in cannabis, they can kind of be like the representative of the social equity applicant company. So that'll be interesting to see how that plays out.
Amazing. All right, we do have a social equity question in the chat. Levon, I believe I'm saying that. I hope I'm saying that correctly. Can social equity delivery type 9 licenses be sold without any issues with LADCR or state? Are we legally allowed to do this on a delivery type 9 license?
Thanks. So selling a social equity business is not simple, and there are always issues. The social equity applicant has to retain 51% of the business, assuming that some deliveries, older deliveries, only require a third of the social equity ownership. Newer deliveries need 51%. So whoever you sold the business to would either have to be a social equity applicant or be partners with a social equity applicant that has 51%, or you can just sell the 49%. And whatever option you choose from above has different regulatory considerations. Most importantly, the ownership change. So you go through an ownership change at the state, you go through an ownership change at the city. If it's a social equity business, then there's an additional equity share review that the DCR conducts to make sure that the social equity requirements are being met. So you can do it, but it's not simple, but as long as it's structured right and the disclosures and the notifications and all of that are done, it should just be sort of like a timeline issue.
Levon, I hope that answered your question. We're going to move on to upcoming licensing opportunities and get to the rest of the questions after this portion of the presentation.
So we talked about the relocation to a new community plan area, PCN, which we talked about potentially in a couple of weeks. You can reapply. There is supposed to be a new retail lottery for social equity applicants, which would come with a new social equity applicant verification process. So if you'll remember, every time we have a round of social equity licensing beforehand, there's a social equity verification process. If you were already verified in the last one, you may not have to be re-verified, but sometimes they require re-verification. I think it depends on the timeline because you have to submit financial paperwork. So if it takes another year for us to get to the next round of retail lottery, then you may have to resubmit financial paperwork, I would assume. Annual applications like we talked about. So as far as applying for a new license, there are various new licenses that you can apply for in the city of LA and elsewhere. But now remember, we're on the annual track for everything. So, it's a lot more of a timeline, whereas temporary approval and a provisional you could get within 2 to 3 months. Now you're probably looking to 6 months, a year, maybe even more, depending on CEQA, which is the big kind of killer there. The DCR has reported that they're looking at providing applications and licenses for temporary events and or consumption licenses, which hooray, this is what we've been waiting for so long in the city of LA. It makes zero sense that there's no legal consumption lounges in the city of LA, no temporary events. We always make fun of the provision of the ordinance that we call the footloose provision, which means you can't have a DJ in a dispensary, like no live music, no music allowed. In one of the entertainment capitals of the world. I don't understand how we can't have that opportunity, but great. There's another issue for MMDs or pre-ICOs that they were previously grandfathered in their non-compliant locations for non-retail use, and that grandfathered sunset is coming up December 31st, 2025. And so we'll probably see some movement on that and the fundamental unfairness of requiring them to move their businesses, but we shall see. And then finally, SB 51, this is an interesting one. This was kind of an underdog piece of legislation that might actually pass, might not. This would essentially extend the provisional licensing application for social equity applicants beyond. So right now, social equity applicants cannot apply for a provisional license with the state, and this would essentially revert that back, and they could apply for provisional licenses up until January 1st of 2031. I think we have a lot of CEQA issues here, so I'm not sure that it's going to pass muster, but we shall see. So with that, I guess we can take some questions, and yeah, what questions do we still have here in the chat?
Alexis Bronson asked, will I be allowed to sell my 51% social equity ownership in a dispensary to a non-social equity person or entity after January 1st, 2025?
Let me get my crystal ball. Hold on. I don't know the answer, to be honest. I'm just being silly. There's always been this teasing of 3 years, social equity will be able to unload their license completely. But I feel like we've been saying that for 3 years, and we just keep saying it. So I don't know. It's all rumor mill at this point, unless and until I see it on a DCR bulletin or agenda or in legislation. I wouldn't bank on it. If you are kind of ready to exit, you can always, come up with alternative arrangements. You can get a management company, you can work with somebody so that, you don't have to be as hands-on or whatever the case might be. But as far as actually selling your 51%, you cannot do that now. And I don't know when you will be able to.
Womp womp. Hope that answered your question, Alexis. AT asks, can you go over the delivery license process for social equity applicant round 1? Sorry, that did not make it for round 1 and 2. How does the licensing process work?
Alexis, you want to grab this one?
Yeah, I mean, as we mentioned, you have to get local compliance first with the DCR, and then the DCC, the application process. I mean, these are 2 separate tracks, the DCR and the DCC. They don't communicate with each other until the very last second. And in that, you have to submit sort of their own sets of forms to them, but a lot of the information kind of overlaps. So a business premises diagram, site plans, a lease agreement, landlord attestations, a labor peace agreement attestation, or a labor peace agreement, an indemnification agreement. There's a surety bond. Sort of when we do the licensing process, we start the local compliance, and then sort of as that's nearing its, final approval, you sort of start the state application process. So it's kind of done in tandem. So then you can get operating as quickly as possible. But yeah, that process takes 6 to 9 months. But now that we're on the annual license, again, TBD, not entirely sure.
Yeah, and I'm not sure if in your question you're asking about the verification windows when you're saying round 1 and round 2, like you were qualified for verification for round 1, but not round 2 of verification. And it's my understanding that you can still apply for delivery if you were round 1 of verification. So I don't know if that was part of your question.
Yeah, AT, if you could give us clarification to help further answer that question, that would be great. And then we had a follow-up from Joseph. He asked the question about the PCN. I believe his question, he said he's still confused. As the first 100 they applied when the DCR ran a check on the sensitive use issue and they were deemed eligible, just as his PCN application. They were the only PCN application that was moved forward, but to be deemed ineligible during temp approval. I'm not sure if there's a question. I think can you maybe?
I think you are still granted like the same right because they have to go through a whole new application process too, which you would have to do as well. So they have to go through pre-application. There's just a different process for PCN versus non-PCN applications. So I get that you don't like that answer and that you disagree with the DCR, and that's totally fair. I get it. I think, everyone should just have a lot easier of a time applying in general. But I think that, as a PCN, you're going to have to go through the same process. And so had you been given like a second chance for PCN, you would still have to go through the PCN process for that new location, which you will be able to do in a couple of weeks.
All right. I hope that helped, Joseph. We have an anonymous attendee. With regard to P3RR1, folks previously ineligible because of sensitive use, CPA, and failure to provide proof of deposit who are now eligible, can they go ahead and reapply with a new business premise now, or is that going to be available at some time in the future?
My understanding is they can go ahead and reapply now. Their records were set to abandoned / refile. So you can begin the pre-application process and the new pre-application record should auto-populate with the retail storefront activity. So, if this applies to you, then you should be able to just go into your portal and reapply when you're ready with a location.
All right, hope that answered that. Gary says he has a P3RR1 application that was recently approved to move forward with a new location deemed to sensitive use. He's saying if anyone is interested in partnering, let him know. And then we have AT. Following up, verified for round 1, did not get verified for round 2 verification, but wanted to confirm that he's eligible to apply for delivery license, even though he was verified for round 1. Or she.
My understanding is that there was proposed location to have those folks sunsetted December 31st of 2022, but I don't think that even made it into the ordinance. So you are still eligible, I'm pretty sure. We had this issue at the end of last year and we decided, I think that they were eligible. We did apply for them after the fact. So I do think you're still eligible.
And then Juan, a real estate broker who has a really great question. How do real estate brokers make their services available to some of these folks that want or need to relocate?
I mean, I don't know if there's like a central place. I would suggest, some of those groups that we talked about, INCBA, LA Bar Association, any other trade associations. In my experience, those are great for ancillary businesses. If you're central to California, you can go to the DCR events all the time. So I would say just general networking. I don't know that I have like a great answer for you on that.
Yeah, networking is definitely a great way. Getting to the cannabis events within the city will definitely get you to meet some people who are looking for you. Roger is asking, can I still apply for a temporary approval license if I'm starting a new application, or am I required to do the annual license process now in LA?
Alexis, you want to take it?
Yeah, you have to do the annual process per June 30th for non-social equity applicants. And if you're a social equity applicant, you have until the 31st. So you've got a couple days, actually, if you can whip it together.
I hope that answered your question, Roger, a couple days. And then an anonymous attendee said, has anyone been able to submit modifications lately? Excella has been down for weeks.
So we've gone through, I haven't actually submitted a modification yet, but I've gone all the way to the payment part. So even though the DCR says that it's corrupted, I'm not really sure what that means. But that's just my personal experience so far.
What do you mean by corrupted? It says. that they-
It says at the top, there's a language in red that basically says, while the DCR is updating the annual licensing process, you're unable to submit modifications because it might corrupt the files. And so
Mm,
it's what, but I've been able to go through the process of going in, entering, an application number, getting through, clicking through the screens. I haven't, like I said, submitted one entirely, so don't quote me on anything, but
That seems inconvenient.
Yeah. yeah, so sorry, that's an answer, non-answer. It's
Yeah.
sort of, I don't really know if it's working.
All right. Georgia wants to know if she has a cultivation license, how does she know which areas haven't met undue concentration?
that's the tricky part. So they're supposed to make that available August 1st, the DCR, that information. And I don't know if they're gonna do it in a map format, which I presume that they would. But allegedly, we should have those answers soon. But you
Don't
would
bet
still
on-
have to go through the annual process.
Don't bet on that date, though. They said the DCR mods would be open by July 14th and it's the 27th, so August 1st could be,
Email them and ask them if we can move forward. Like maybe they just forgot to remove that headline.
yeah, I don't know.
Weird.
And then I believe you said that the cultivation situation is kind of a mess anyway. I'm just waiting for the dust to settle.
Yep. Yeah, that's
Okay.
right. So we really have very little information. Let me see about the CPAs for cultivation. But they're supposed to put out like some sort of report or an updated map, in the next few days. I did get some information on those community plan areas, but I don't remember what it was. So, kind of attached response. So, yeah, it's supposed to come out in a few days. I have a few locations that supposedly haven't met undue concentration. But it hasn't been confirmed yet by the DCR, so I wouldn't want to share it at this time, but when the information comes out, we'll share
Someone asked, what is P3RR1?
it. That's phase 3, round 1, so that was September 3rd, 2019, I believe was the date. That was the date that the race to the retail licenses occurred. And they are calling, so that was phase 3, round 1, and then phase 3, round 2 occurred most recently, where another 100 retailers were selected in a lottery. And so right now in the licensing process, we're in phase 3, and each retail window that opens up will be an additional round. Included in phase 3, though, are all other licenses as well. So if you're applying now, you're applying in phase 3. If you're applying for retail, you would be applying in round 3, phase 3, round 3.
Hope that answered that for you, Bruce. Ryan is asking, how long does it take right now to get a license in Los Angeles?
It depends. The
Not a
lawyer
lot.
there, it depends. So depending on what kind of license type you're looking for, whether that license type is available, whether it's social equity, not social equity, the location that it's in, all of the above, but assuming that all the stars are aligned and you're, ready to submit an application. Remember, you are submitting under the annual process now for the city, which not a single person in the city of LA has an annual license. And so effectively that process hasn't even been flushed out. People have not gone through it. You need to go through that emblem program that Alexis described, like all of these different requirements for the annual at the city level. And then you also have to do it at the state level. So I would say, at least a year. I would budget for, and remember, you have to hold on to the property for that long or have some sort of alternative agreement with the landlord where he says, yes, when you get a license, he or she says, when you get the license, you will be able to occupy and start paying rent. So that's the long and short of it. That's highly speculative because we're still figuring out all this annual stuff. In light of the sort of market conditions, buying a license has never been cheaper. And so, not saying that that's not a lot of money, it is significant capital still, but if you want to start operating right away, that's probably the best bet. If you calculate in how much, a year of months, a year of lease and licensing and all of that is going to cost, you'll probably end up in a similar ballpark.
Thank you. We have a question about social equity applicants. Is there a limit, state or county limit for social equity applicants on how many licenses they can apply for and license type? So for example, if you apply for a retail location, can you then apply for a micro or any other type of license?
Alexis, do you want to take the question?
Yeah, from my understanding that there is no limits on how many licenses that you acquire.
Yeah, each city has its own rules. So as far as the city of LA goes, there is like a limit on the number of retail licenses you can have. I think it's 3. And also like aggregate square footage, there could be a limit on at the city. So it's not like the municipal code lays it out in the city of LA, what those are. In the state, there are no limits as far as retail, any of those other types of licenses. Cultivation, there used to be a limit. And I think since 2023, Jan 1, they've allowed, the square footage to essentially be limitless, as you can now apply for a large license. But every county and city is going to be different. Retail licenses are generally the most sought after, and so they are the most sort of controlled by the locals, and so that's where it's hardest to get a license.
It says, thank you. And then Yasmin has asked, she says she was verified for social equity before. Does she need to get verified again to apply for the next lot?
Depends on when you were if you were verified in this most recent round for retail, then you may not have to be re-verified. Like I said earlier, I think it depends on the timeline of when the next lottery comes out. If the next lottery takes like a year to come out, you may need to resubmit financial documents. But if you were verified in the very first round, in 2018, 2019, then you do need to get re-verified.
Mhm.
And that process will open up right before the next retail round.
All right. And then someone is asking, is DCR accepting cultivation licenses right now?
Cultivation, they're not accepting. They are accepting nursery for social equity applicants. Cultivation is probably going to hinge on the PCN analysis. So any, not PCN, undue concentration CPA analysis. So if it's a community plan area that has not met undue concentration, you may be able to apply at some point in the future for a license there. It also might be wrapped into the PCN process. So, you may be able to apply in an area that's met undue concentration so long as you go through the PCN process. The PCN process stands for public convenience and necessity. So you're essentially arguing for or requesting a variance to the undue concentration. So if it's 10,000 square feet of canopy that's allowed in a certain community plan area and it's met that 10,000 and you still want a license in that area, you're going to have to put together documentation that shows that you would benefit that area generally in order to, by operating this business, even though it's met undue concentration. And essentially you'll need to get the council member for that district to approve your PCN application and the rest of council to also approve it.
Thank you. Juan would like to know if you assist people in San Bernardino and Riverside counties.
Yeah, we help people throughout the state of California. We're headquartered in the LA area, and since it's the largest market in California, that's where a lot of our clients are. But we also have clients throughout Northern California, further east, San Bernardino, Riverside. So absolutely, we can help.
All right, and we have our last question here from Joseph. He is asking, with the new PCN opening, do applicants that were verified in 2019 have to be verified through the new verification process?
Yeah.
Yes. All right. Thank you so much for attending, asking great questions. I hope you learned today. I definitely did as a non-license holder. Wishing you all the best of luck. If you have any questions, screen grab this screen right here. It is Mansouri Law's website, phone number, and Instagram. Make sure you follow them on Instagram at 420 Attorneys. I've been your host, Tammy, aka the Cannabis Cutie, also my Instagram handle. And I am thankful to have been here today with you all.
Thanks, everyone. Thanks, Tammy. Thanks, Alexis.